Next, we have Howard Nations. You know, I originally saw Howard Nations in 1980. I went to a then Atlas seminar, and everybody was going into this room, and it was near the end of the day, and I noticed that they were all flocking, though, instead of to the bar, they were going into this one speaker's room. And there was a tall, white-haired gentleman standing up on the stage. And it was obvious that the people were coming into this room because of who the speaker was. I'd come through a time in the trial lawyers bar that I was fortunate to hear a lot of people. I remember the Becktons and the Twiggs and the Philos, the Prizers, the Koskos, the Levines, the Lamberts, the Hermans, Deeds, Spencer, Cochran. A lot of names that have spoken at our functions and tried to teach us that advocacy is a journey and not a destination. But I don't think I've learned any more from any one individual than I have Howard Nations. Howard's been practicing law since 1966. He co-founded this whole college, National College of Advocacy. He took the old education department of ATLA and said it could be much more. It could be an academic incubator. It could be a practice, trial, advocacy experiment that people could come to conventions and colleges. He was one of the people that thought we could have 3- and 4-day colleges to teach our lawyers to be better and hone their skills. He was a pioneer in the whole use of technology and neuropsychology as these fields opened up and taught us more about persuasion. Every single organization I have ever belonged to, Southern Trial Lawyers, National Trial Lawyers, the Belle Isle Society, Howard has belonged and not only belonged but received their highest award. His awards include the Heavy Lifting Award, Tommy Malone's Great American Eagle Award, the Clarence Darrow Award, the Mel Belle Isle Award, you name it. In any organization that means anything to trial lawyers in this country, Howard not only has participated, but he always seems to have the highest award. You know, W.B. Du Bois talked about the talented 10th. He said in each profession, there'll be that 10%, that talented 10th. Well, Howard Nations occupies rare ground. He is in that 1%. If you have somewhere else to go, get up, but I tell you, you don't want to miss a minute of this. Howard Nations from the great state of Texas.
Well, good morning. Damages themes emerge from evidence of damages, from your evaluation of evidence of damages. That sounds rather obvious, but it's not, because I'll tell you that there was a study done, a forensic study done, which did not surprise me at all. What do you think is the least discussed topic in jury deliberations? This was done with studies of actual jurors in real cases, not just focus groups. Well, I'll take the suspense out of it. It's the evidence of damages. They'll talk about numbers all day long, but they won't talk about the evidence of physical pain, the evidence of mental anguish, the evidence of physical disability, the evidence of physical disfigurement. Why? 2 reasons. One is nobody really likes to talk about physical pain and much less put a dollar value on it. But the main reason is us. We fail miserably in applying the availability principle to damages. The availability principle says that the jury will focus in deliberation where the spotlight is placed during the trial. Too often, we regard damages as something to think about the night before we do a closing argument, or let's save damages for the summation. Damages proof. I mean, I don't know. I've never figured out how to deposit 1/3 of liability in my checking account. Damages proof is why I'm there, to get the recovery from my client that my client deserves. So I want to talk to you about why I think we fail to make damages available and how we might go about curing that a bit. themes emerge from a very careful evaluation of damages as you go through. Let me tell you how I think, where I think the starting point is to looking for your proof of damages and looking for your themes that will emerge on their own. You should create a body of evidence with respect to each element of damage. We have a tendency to lump things together, pain and suffering, mental anguish. We have a tendency to not mention the physical disability and things of that nature at all. But we need to create a body of damages with respect to each element. Now, first of all, you need to know what all your elements of damage are. We miss many, many elements of damage. So we have, I'm going to fly through this very quickly for you, but we have these checklists that we use in each state where we do business as to the recoverable elements of damage. So you have a checklist so that you go down and you look at each element of damage and you make sure that you are pleading and proving every element of damage to which you're entitled. There are horror stories about how you miss the massive recoveries, very large recoveries, recoveries of attorney's fees, things of that nature, which are statutorily provided sometimes. They're missed because the attorney does not plead them and doesn't prove them. So first of all, check and make sure that in every case that you are in fact pleading every single case, every element of damage that you have. So we'll go through these elements of damage. This is just the list of what you're entitled to, what you may be entitled to, but you need to check off everything to make sure that you're pleading for every single thing. All right, so I want to talk to you. Once you get your element of damage, make sure you've got all your elements of damage identified. Here's what we do. We create a body of evidence with respect to each individual element of damage. How we evaluate this through the segmental approach to proof of damages. And let me just tell you that all this information is in a paper on my website, howardnations.com, under publications, and there's a paper in there on settlement negotiation that has all this set out in it, and then it has the demonstration arguments that I'm going to show you today. They're set out in there also on the persuasion paper. For example, you take physical pain, and you see. You talk to the client, and we use these to interview our client. This is how you gather your information. And we'll talk to the client in terms of, I want to take you back now to the instant of impact. And tell me what you recall about physiologically, what actually happened to you physically at impact. What hit what hurt, what did you damage in the impact? And you take them through the physical pain. There's a post-impact period that's unassisted, which is quite often a source of mental anguish and physical pain. The period of peril is when you get hit on the freeway and then there are cars zipping by and you're sitting crossways and you're waiting for that 18-wheeler to come up and hit you. During rescue, remember this, during rescue, just as an example, I'm going to fly through this. This is a whole separate one-hour speech by itself, but I'm just showing you the concept. During rescue, for example, a lot of good Samaritans who are at the scene will be intending to do good. They'll be very well intentioned, but in the process, I'll give you a quick example. I represent a young man who was on his honeymoon with this fine young bride, and they were driving along right next to the border in South Texas, and it was next to rice field. And this big rice thrashing machine, fellow driving along on the shoulder in a rice thrasher, swings out over the freeway, over the road, it's a 2-lane. And when he does, it takes the top right off of their car, just like a can opener, just peels the top back off their car. So he's spinning around, he smells gas, he's in extreme pain, and when he stops, he can't move. Now, he was a medic in Vietnam, and he was very well aware of injury, and he was very well aware of paralysis, and he can't move. He's sitting there, he smells the gas, he calls out to his wife, she doesn't answer. So finally, he has some movement in his right hand, and he reaches up and grabs his own shirt and pulls himself as far as he can reach. He pulls himself, his whole upper body around until he can see his wife, who has been decapitated. Now, you want to talk about all the various levels of physical pain involved in that? The physical pain comes from the fact that he has broken both legs. He has 2 broken scapulae. He has all kind of broken ribs, and he has this obvious injury to the neck. Mental anguish is a whole separate element of damage. Think of all the actual mental anguish that arises out of every physical injury is accompanied by the mental anguish. But the mental anguish involved in that picture that will never leave his mind ever for the rest of his life of his wife, that's mental anguish. Mental anguish is also the fact that he is legitimately fearful that he is quadriplegic because he cannot move his upper body with the exception of just some movement in the right arm. So you go through now, as when he's being rescued, two men stop and they smell the gas. They reach in and they take him under the arms. They pull him out and he's telling them, be careful, be careful, be careful. And they take him under his arms and they drag him away, and they're dragging him across the ground, well-meaning, but you know, he's got 2 broken legs, 2 broken scapulae, and they're dragging him away from the car because they're afraid it's going to burn. Okay, that's during rescue. During transportation, when they took him to the local hospital, and they said you're far too serious for us, so they had to hire a medevac plane to take him to Houston, to the serious injury unit. And so during transportation, he's locked down the whole time, got the blocks around his head, can't move his head, they won't let him. Mental anguish. Can you imagine the mental anguish that he had there? And overlaying on top of that is the mental anguish about his wife, what he's just seen and witnessed with his wife. The emergency room care. Remember that when you're on the scene and in emergency rooms, physical pain, all the stuff that's done for you there, they do cut downs, they do all sorts of emergency things. All that's done without any type of pain relief. It's done without anesthesia. So there's a lot of pain involved there. So here's an interesting exercise you can undertake. Look from the time of injury, calculate in the medical records when the first time the person actually gets any type of medical relief, any type of anything, pain reliever or anesthesia, anything that will stop the pain. You will find sometimes it'll be 24 hours because of differential diagnosis. Pain is an important part of differential diagnosis, so doctors make absolutely no effort to stop pain. They need the pain to help them diagnose what's wrong with you. So you have all sorts of pain and mental anguish evidence from that type of proof. The differential diagnosis itself, a lot of times the testing is very painful, the type of testing they have to do. Another thing is a very important point, your major versus your minor injuries. When we have a serious injury, like a paraplegic, for example, we may ignore the other injuries that the person has, so we're so thoroughly focused on the big injury. What I do in that case, and this is an exercise I've been doing for a very long time, I'll take a paralytic, and I'll take the paraplegia case, and I'll tell one of my associates, okay, you forget about paraplegia. You take this person and go analyze every other injury they have and analyze their entire case in the absence of paraplegia. And you'll find a lot of damages there that are all added up and cumulative with the paralytic damage. There are all sorts of damages involved in treatment and therapy. Between therapy treatments, patient decision making is I had an 18-wheeler driver who was given eight hours to decide, come back the next morning for surgery. He's in his hospital room, the doctor's coming back, he says, by tomorrow morning I have to know if you're willing, if you want to have an amputation or risk death. And so that's a very long night. Informed consent, some of the things contained in informed consent, that you may die, you may get AIDS if there's blood transfusion, all the things in the informed consent that they have to sign cause mental anguish. All kinds of testing, surgery, post-operative a recovery period, prosthetic. You get a lot of times your rehabilitation therapists are very, very good witnesses on mental anguish. Physical pain, obviously, but there's a lot of mental anguish in learning to walk again when you've had a leg amputation. So these people make very good witnesses. And now when you return home, the duties, the thing, and then the next one's the recreation. This is physical disability. Physical disability is those things that you can no longer do that you did before, which were not part of your earning a living. And when you return to the workplace, you find good witnesses here. The employer has them back on the job, but then the employer comes in and talks about all the things they cannot do now that they could do before. I can't assign that to them anymore. That's damage to wage earning capacity. That's a big damage item. Future damages, your life care plan, life expectancy, and always plead future damages. I taught damages in law school for 25 years, and one of my young associates came in one time and he said, you know, I'd hired a new associate from the school, and one of my attorneys came in and said, you know, he really took you seriously here about you telling them to always plead future damages, because if you plead them and you don't prove them, no harm, no foul. But if you don't plead them and you try to prove them, you may have some difficulty with amendment. So always plead them. And he said, yeah, read this. And I read a petition he drafted, and it said, decedent has experienced funeral expenses in the past, and in all reasonable probability will experience funeral expenses for an indefinite period of time in the future. And I said, well, I called him in. I said, what are we dealing with here, the eternal flame? And he said, no, the suit was rented. So I apologize for that. I was sorry, seriously. Okay, so now here's what we do. We take the element of physical pain. We put it up on the wall in our war room. And then physical pain. Under that element, we list who are the lay witnesses who can testify to physical pain. Who are the expert witnesses who can testify to physical pain? What is the documentary evidence? The medical records, whatever. Test results, whatever. That will be evidence of physical pain. And then demonstrative evidence of physical pain. They would do the same thing separately with mental anguish, with physical disability, physical disfigurement, whatever, with every element of damage that we have. So by the time we finish, we have the war room covered all the way around the wall with every element of damage. Now what you can do at that point is you can then stand back and you can look for the holes in the evidence. You can look for what is not here. Your lay witnesses, then you try to find, if you find out that you don't have enough evidence at the scene, you've got, okay, who were your people at the scene? The defendant is often a very good witness for the physical pain and mental anguish of the plaintiff at the scene. The defendant was there, the defendant driver was there, and they can be put in a very bad position. If you've got an obviously injured plaintiff, you ask them about what they saw and what was the pain and suffering what was the plaintiff going through it, and what kind of problem was he having, and what did you do to help? Did you call 911? If it's an 18-wheeler, they'll say no. Who'd they call? The dispatcher. So here's a man in all kind of bad shape, and all the defendant who caused this is calling his dispatcher so they can get their people to the scene. So we go through all the lay witnesses. We put that up there. All your health care providers, your rehabilitation team, your life care planners, those are your expert witnesses. Then we look at this. We stand back and we look around the war room and we say, okay, where are the holes? Where do we not have evidence? So then we look at, 1, what is available? 2, how can it be simplified? 3, how can it be enhanced? You take an x-ray and turn it into a positive, something that obvious. How can it be enhanced? And then, if there's no evidence, what can be created? Do we need to do an animation? Do we need to do additional testing? What do we need? And we do that with every element of damage. Let me talk to you a little further about what we do is, I think that we have to create, not only after you create the body of evidence, we have to start making damages available. The availability principle. Jurors will deliberate in their deliberations. They will focus on where we focus the evidence in the course of the trial. It's very simple. They'll look at what we make available to them. So we have to start making damages available to them in opening statement. And here's what I like to do. I like to set up signposts. I like to prime availability of damages in opening statement. And the way you do that is you explain to them what their role is. One of the things that you'll be called upon to do as a juror in this case, you are the sole judges of the damages. You'll be called upon to place a monetary value on physical pain, mental anguish, and so forth. Now, you tell them this so that they understand why you're not just putting on whiners and groaners, you're putting on evidence of physical pain and suffering for a reason, because they have to decide on it. So then I explain that my job is to bring you that evidence. I'll have to bring you evidence of physical pain and mental anguish and so forth. Now, what you're doing at that point is you're priming them so that as you get to evidence, as you get to testimony, for example, you have a doctor on the stand, you say, all right, now here's your signpost. All right, doctor, let's turn to the physical pain that was associated with this treatment. All right, doctor, let's talk to the nurse. Let's turn to the mental anguish that you witnessed while you were treating Mr. Jones. So as you're going through, you're saying, okay, here's that mental anguish evidence I promised you. So you go through all that. And throughout the entire trial, you're using those signposts. And then they understand what your role is, that you're not just trying to do to get sympathy, that you're doing what the law requires you to do. So when you build your body of evidence and you have each element, then you bring your evidence to life with metaphors. You set up your summation. For example, I tried a case back when the earth was cooling, and it involved a 9-month-old infant who was given an overdose of digitalis, and it had digitoxin toxicity, as a result of which the child went into heart failure on 15 separate occasions in a very short period of time and had to be defibrillated 15 times. Now, the problem with defibrillation is the term defibrillation doesn't execute the required level of emotion that Aristotle says we need. And nobody knows what it is. They hear it, they see it, it may involve something about paddles, but what really happens in defibrillation? So I need a metaphor. So we're going down to, we tried this case in Beaumont. My doctor and I are driving down there. He's going to be on the stand. And I'm saying, okay, doc, I need we got to have a metaphor for this. We can't talk about defibrillation. Describe defibrillation for me. He said, well, what happens is that the heart starts fibrillating, which means it sits and starts squirming. Instead of pumping, it's squirming like a can of worms. And then the next signal, you put the electric paddles on and you send an electric charge through the heart with sufficient force, it stops the heart from beating. And then the next signal from the brain starts the heart to pumping again in the normal fashion. It's just like what? Electrocution. You send enough electric force through the heart to stop it from beating. So all of a sudden I said, okay, you tell it that way on cross-examination. And so he did. He explained defibrillation on cross-examination. If he hadn't, I would have gotten it on redirect, obviously. But he put that in. And so what does this do? This allows me, by thinking about damages ahead of time, this allows me to argue to the jury in terms of how do you even begin to place a value on the electrocution of a child, of sending an electric charge through a child's heart with sufficient force to stop that heart from beating. And then that's up to you. It's your determination. And then you suggest, you know, it may be $5,000, it may be $10,000, it may be whatever. That's up to you. But when you arrive at that number, multiply it times 15. And that's what they did. And the result was I got The only remittiture I've ever had in my life was the argument for 15 electrocutions, and I got remitted on it. I didn't get, I mean, I still got the largest recovery in Texas on it, but even after the remittiture, but they bought the argument. So they bought the metaphor, in other words. I don't think I would have gotten that if I just stood up and argued for 15 defibrillations, okay? Damages have to be proven in context. Context is, we're proving three things. We're proving it in the context of life experiences. And we're proving three different things here. One, the life of this plaintiff before. Okay, what was his life before? Compare it to what is this plaintiff's life now? What are the losses? What are the differences? And then third, what will this plaintiff's life be like in the future? So you have those three things. Now, in context, I always like to prove in the context of life experiences. So I'm going to talk to you for a minute. I'm supposed to give a couple of demonstrations here. So let me talk to you about well, let me just give you a demonstration, then we'll talk about it. Ladies and gentlemen, we're here today because 3 years ago, on Thanksgiving weekend, Dave Wilson was doing what many of us were doing. He was in his den, getting ready to watch the Longhorns and Aggies do battle on the gridiron. When Ann, his wife, walked in, and she said, "Dave, I don't have any hot water. The heater's out." So Dave said, "Fine." So he goes down to the utility room. So we see Dave go to the utility room. He kneels to read the instructions on the water heater. He smells the faint odor of gas, and he finds that the pilot light's gone out. So he reads the instructions. The instructions say, when the pilot light goes out, wait a few minutes and then light it again. Now, in this case, you would put that up on the board so they're reading it with you, obviously. Dave follows the instructions carefully, thinking, as we all would, that the gas shut-off valve on the water heater will work the way the manufacturer said it would. Now, we see Dave go back down during halftime, go back to the utility room where he no longer smells the gas odor. He takes a long wooden match and he strikes it on the concrete floor. And we see him as he reaches in to put the flame next to the pilot light. Then we see a look of instant panic on Dave's face as he hears the whoosh sound. He sees the flickers and the flash and then the flames, and he feels the searing heat. Dave doesn't realize that the pungent odor rushing up to his nostrils is from the singeing and charring of his own flesh. We see Ann rush to the basement, and she sees Dave as she hears the screams. They're emerging from this large ball of orange fire, and she hears his tormented cries. They managed to cover him up and put the fire out, but it's so late. Like a lobster thrown into a boiling pot, this gentleman is cooked from his ankles to the top of his head. Not an inch of skin is spared from that awful blaze. Not his ankles, not his thighs, not his stomach, not his chest, not his ears, which are burned off. We see more than 4 weeks, 32 long days and nights dragged by in the hospital burn unit. Ann is sitting constantly by his side. Days and nights of Dave and Ann measured minute by minute by minute of misery, pain, anguish, despair, hopelessness, until Dave finally finds the only peace that's available to him, the peace of death. Sometimes in the quiet and lonely hours of the night, Anne still hears the echoes of Dave's screams, and she awakens to her own screams. And the vision of Dave, her husband, father of her children, the love of her life, the vision of him captured in that fiery ball of flame. That, ladies and gentlemen, is why we're here. Because Dave Wilson trusted this manufacturer and followed the instructions on the water heater with the shut-off valve that didn't really shut off the gas the way the manufacturer promised it would. Okay. What you're doing is you're tying in, these are normal life experiences, okay? So you're tying in their life experiences with the same life experiences you have. People resonate to life experiences. We make our decisions based upon our life experiences. A lot of other people were sitting there on that Thanksgiving weekend watching football like Dave was. But Dave ended up dead. Why? Because of this manufacturer. Now, what you do is you can test an argument like that, and you can test your damages with focus groups. Focus groups will give you they'll give you the information that you really need. They'll give you your themes. They'll give you the language of your case. You give them a presentation of vanilla facts and listen to how they discuss them. Listen to how, and a lot of times I'll just ask them for metaphors. I'll say, finish this sentence for me. And then I'll give them the facts of the electrocution of the baby, for example. And I'll say, okay, now, this defibrillation is just like, and everybody write down their answers and see what they come up with. They'll come up with much better stuff than I can, I promise you. They're extremely valuable. Now, there's another one I want to cover with you very briefly because it's a different approach. It's a case I tried a few years ago. And this is the closing. I'm just going to take a couple of excerpts from the closing argument. But it's the death of a child. How do you argue for damages for the death of a child? And you have to intersperse some anger against the manufacturer, interspersed with your losses. And how do you measure a death? So let me just give you a quick example about asking for money for the death of a child. Now, we talk of money. We talk of money because there is no magic. Is anyone so callous as to believe that if you as a jury could wave a magic wand and bring young David Taylor through that courtroom door, that there would be talk of money? No. What you would see is this young couple emerge from the depths of despair into the heights of happiness as you see three people wave goodbye to us and leave this courtroom again as the happiest young family on earth. There would be no talk of money. But there is no magic. There's only despair. There's no magic. There's only reality. So since there is no magic, we talk of money. Magic exists in the world of children. The magic for each new day for young David, 7 years old. Playing with his cousins, hitting the ball as far, running as fast. The magic of his beautiful young white puppy, Snowball. The magic of playing ball on Saturday in Pee Wee League with his father as a coach. That's the magic of youth. But the magic in David's life ended 3 years ago when this defendant made the horrible, treacherous, profit-motivated decision to leave this product on the market, the product that exploded and caused the death of this young man. They knew it was defective, and yet in the boardroom, they made the decision to leave it on the market. Why? Because recall would have cost them $4 million. So they decided it's better to gamble. So they gambled young David's life. They gambled that they would never be caught. They gambled that their lawyers, if they did get caught, could talk their way right out of it. So you're called now to try to place a value on the death of a child. But let me suggest to you, in order to do that, don't look at the death of this young man. Examine closely the life that never will be. This young couple will never again share the daily joys, fears, hopes, and tears of young David. David Sr. will never know whether his fine young man would have followed in his footsteps. But they also lost those special moments that reward parents so beautifully. They'll never experience his graduation from high school, the prom, the senior prom, his graduation from college. They'll never have that day when he walks in and says, "Mom, Dad, this is the woman I'm going to marry." David Sr. will never receive that wonderful phone call. "Congratulations, Grandpa, it's a boy." And David's mother will never again hear the four most beautiful words in the world: "I love you, Mommy." Days of family tradition and enjoyment in America. Mother's Day, Father's Day, birthdays, Thanksgiving, Christmas are now days of mourning in the Taylor household. Can you imagine Christmas without the child? Now, ladies and gentlemen, you're now called upon to write the final chapter in the life of young David Taylor. You have to answer the question, what is this young child's life worth in our community? But before you close the books on young David Taylor's life, examine closely the books of this corporation, because as we speak here today, the death of young David Taylor is carried as a $4 million profit item on the books of this corporation. Okay, this goes on forever. It was, now, I bring that to your attention for this reason. You need to have a reference point. You need to have a point for damages. Nothing falls flatter than walking to the board and saying, well, let's see, we'll fill out this. Okay, for pain and suffering, mental anguish, $500,000. Really, why not $5 million? Why not $500 million? Have a reason for find a reason for your damages. My damages in this case were, the argument was $4 million. They gambled to save $4 million. If you award $4 million, they've won because it cost them nothing. Instead, this is egregious conduct. We have a simple system in the state of Texas for egregious conduct. It's called treble damages. So if you award $4 million compensatory and $12 million punitive damages, you'll be communicating in the only language that corporations understand, the language of money. So you see, you have to have a reason. The McDonald's case, you know where the number came from in the McDonald's case? The sale of coffee by McDonald's, one day's coffee sales. But you need to have something. I say your themes, that sort of thing, they emerge from your facts. So you have to deep dive into your damages and get into your facts, and the damages will emerge and take care of themselves. I have one last thing I'm going to do, and I think it's important and it's the way that I try to overcome what I said, that plaintiffs never, the juries don't discuss damages, the elements of damage in the jury room for two reasons. One is we don't give them evidence of damage, but the other is we have to call upon them. We have to empower them, but we have to tell them what their duty is. So the last thing I'm going to do is just a sample regarding their duties and call upon them to meet that duty. So here, this is from another case I tried. But I do a sample of this. I do some form of this in every case. Okay? Ladies and gentlemen, the quality of the first 14 years of Annette's life was the responsibility of her parents. The quality or lack of quality of Annette's life for the last 3 years since this tragedy was the direct responsibility of this defendant. But the quality of the remainder of her life, her 65-year life expectancy, the quality of the next 65 years is directly in your hands. On voir dire examination, we advise that the 12 of you who are chosen would have the difficult task of confronting, carefully considering, and calculating the dollar value to compensate for 65 years of Annette's lifetime companions of physical pain and suffering, mental anguish, physical disability, and physical disfigurement. Now, such a grisly audit is difficult, but it's indispensable if the injustice which has been done to Annette by this defendant is to be overcome by your verdict. You must meet your full duty, follow the court's instructions, and fully evaluate Annette's physical pain and suffering, mental anguish, physical disability, and physical disfigurement. But as you sit in that jury room and to discuss the evidence of these devastating damages, remember that you and I only have to talk about them. We only have to view them. We only have to think about them and discuss them. Annette has to live with them every second of every minute of every waking hour for the rest of her life. Now, the hardest part of any trial for the lawyer and for the parties is waiting for the jury verdict after deliberations begin. But your decision is so crucial to how Annette spends the next 65 years of her life that we will wait as long as it takes for you to fully evaluate each and every piece of evidence on each and every element of damage concerning Annette's physical pain, her mental anguish, her physical disability, and her physical disfigurement. Annette has waited 3 years for this, her last day in court. If we have to wait 2 days or 10 days for you to arrive at a verdict which you can look back upon with pride for the rest of your life, we'll gladly wait. We understand that reviewing all the evidence and carefully considering all the damages is your duty. So you take all the time it requires. We will wait. And now we discuss the individual damages. So that's what I call the altar call. You tell them their duty and tell them to take all the time they want and just hope that somebody in the jury room holds them to it. Okay, I hope I've said something that'll help you help your clients. Thank you very much. Thanks, man.